Calling 2024 CR 4973, State of Texas versus Richard Trujillo. Could I have parties announced for the record for the state?
Andrew Harris, Sigmund.
Defense,
Anita Perez for the defense.
and are you Mr. Trujillo?
Yes, sir.
Counsel, have you received all the discovery? Did you review it with your client?
I have you.
Court will find that the state is in compliance with discovery. Mr. Trujillo, did you review the document entitled Application for Community Supervision with
Yes.
your attorney?
Yes, Judge.
Did you understand it?
Yes, Judge.
And did you sign it?
Yes, Judge.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Judge.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Trujillo, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney?
Yes, Judge.
Did you understand it?
Yes, Judge.
Your Honor,
Did you? Yes.
I apologize for interrupting, but should we have a court reporter for this proceeding?
Oh, yes, we should. Where is she? Okay, we'll wait for her to come back.
Disagree.
Okay. Hey, you know what? Maybe I should do that as well. I'm gonna take some notes. Thank you.
Welcome, Your Honor.
Wow.
I didn't see either.
We didn't see it either. The only person who caught it was the prosecutor.
Said 5 minutes, so.
Yeah,
I
5
think
minutes.
it was 3 or something, so she's waiting for the 2 more minutes.
Ah, okay. Who's here on, while we're waiting for the court reporter, who's here on Mark Anthony Morgan?
I am.
Court is calling 2024 CR 4973, State of Texas versus Richard Trujillo.
Actual local jail time served. The 14th of March, 2024, 6 days, PR bond. The 3rd of November, 2020, 7 days, released on bond. The 7th of April, 2017, 3 days, contempt of court refused to testify, released per court order. The 27th of August, 2013, same day, released on bond. The 6th of November, 2013, 16 days, contempt of court, released on bond. The 13th of December, 2012 to the 2nd of November, 2013, contempt of court, released per court order. The 22nd of August, 2012, 6 days, contempt of court, refused to testify. The 8th of November, 2011, 5 days, contempt of court, released per court order. The 28th of September, 2009 to the 16th of November, 2009, contempt of court, released per court order. The 19th of September, 2008 to the 11th of May, 2008, sentence expired early. The 3rd of April, 2007, same day, released on bond. The 14th of April, 2005, 6 days, contempt of court, refused to testify, released per court order. The 16th of October, 2003, 4 days, contempt of court, refused to testify, released per court order.
February 2nd, 2002 to July 23rd, 2002 sentence expired. January 24th, 2002 same day released on bond. June 21st, 2014 days transferred to. January 16th, 1999 same day released on bond. December 9th, 1997 same day PR bond. December 10, 1995 same day released on bond.
Could I have parties announced for the record for the state?
Andrew Harris, Sigmund.
Defense,
Anita Perez for the defense.
and are you Mr. Trujillo?
Yes, Your Honor.
Did you understand you're charged with driving while intoxicated, third or more? That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Judge.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $500 fine. State recommends community supervision. The DWI intervention course, victim impact panel live, ignition interlock for half the term. Did you understand that to be the plea?
Yes, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There'll be 120 hours of community service restitution, 30 days house arrest in lieu of 10 days in the Bexar County Jail. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Yes, Judge. So my client, I obviously, as the court's aware, this is his actual 3rd DWI. He is, how old are you?
52.
He's 52 years old, Judge. My relationship with him started pretty quickly. We went over the discovery quickly right after I got appointed. He immediately enrolled himself in AA, and he has been regularly attending meetings. He's in a program, with Grupo Unidad, I believe it is. And he has his log, if the court wants to see it. He's been in compliance with obviously admission interlock. I believe, as far as a condition of probation, as far as the house arrest, the only request that we would make was that he be allowed to go to work, and that would be between 7 and 5, and to continue, going to his AA meetings, which are between 8 and 9:30. I mean, I'm sorry, it's from 8 to 9:30 is the meetings, Judge, and we ask that you, follow the legal bargaining agreement that we have with the state. If I didn't say it before, Judge, I'm so sorry. This is the third DWI. The last DWI was in 2008, and obviously the first was in 1995. It's been a while, but he acknowledges, and that's why he's an AA judge.
All right, how often are you going to your AA meetings?
I've been going every day.
Okay. Are you employed?
I have this one.
What do you do?
I have my own business,
Doing what?
window tinting.
Okay. All right. Do you have any children?
Yes.
How old are they?
Oh, the oldest is 28, 25, and then 20.
All right, this is what the court is going to do. The court is going to sentence you to 5 years in prison, suspended and probated for 5 years. There's a $500 fine that will be probated. Proof of employment within 30 days. No employment as a home healthcare provider with minors. DWI intervention, DWI education, victim impact live, ignition interlock for half the term. There is to be a 2-year driver's license suspension. I can either sentence you to 10 days in the Bexar County Jail, or I can place you on partial GPS for 60 days. And that will be allowing you to go to work and your meetings only. Do you understand?
Yes, ma'am.
And the reason why I'm giving you that option is because I know that there's some jail overcrowding and also the whole issue with the Tyler Odyssey system. So 60 days partial GPS or 10 days in the Bexar County Jail.
60 days.
All right. So it'll be 60 days GPS partial for employment and for his sober support meetings, 2-year driver's license suspension, regular reporting by Zoom or in person, regular random UAs, make sure they test for alcohol. We'll do a referral to felony drug court. And there's to be 120 sober meetings and 120 days. All right, field visits, 1 time per month for 4 months or until in treatment. And 120 hours of community service restitution. All right, anything else, probation? Is there anything else you need from the court to be successful?
No.
All right, we can go off the record. Here's the thing, you're one of those people who can't drink alcohol at all,
Correct, Judge.
not for any reason whatsoever. So don't drink alcohol. You know you can't do it. You understand?
Correct, Judge.
If there's an issue, let probation know. If you feel as though they're not addressing it, you can always come back to court and we'll address it. All right, good luck to you.
Thank you, Judge.
You're welcome. Who's here on Patricia Munoz? And probation, this is an application for deferred. Court is calling 2024 CR 2942, State of Texas versus Patricia Munoz. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
For the defense?
Anthony Cantrell.
Are you Patricia Munoz?
Yes, Your Honor.
All right, defense, you filed a motion to quash the indictment. Are you withdrawing that motion?
We are, Your Honor.
Any objections to withdrawal of the motion?
No.
All right, then the motion is withdrawn by defense. All right, Ms. Munoz. Did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Did
Yes,
you
Your Honor.
review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, it appears that you only proceeding on count one.
That is correct.
Any objections to the waivers of count two?
No, Your Honor.
Any, state, are you proceeding with the party language?
They are not, Your Honor.
We are not. Judge, just states replacing Jason Garrett with Zach.
All right, thank you. All right, Ms. Munoz, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney?
Yes,
Did
Your
you
Honor.
understand it?
Yes.
Did you sign it in all the appropriate places?
Yes, Your
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison? Did you understand?
Yes, Your Honor.
All right, go off the record for a moment. Could you mute us, please? All right.
If it's of any value to, Jason emailed the relevant people, Elaine and others, like 10 minutes ago.
Okay. All right, so we're back on the record. According to the plea bargain agreement, state is proceeding on count one. State will remain silent on your application for deferred adjudication. There's an affirmative finding of family violence. There's to be no contact with Miranda Medellin, no contact with Renee Vasquez II. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea?
It is the plea.
And outside the
Sorry, Your
agreement,
Honor, I need to just.
yes.
State has a motion.
Yes, Your Honor, we would like to orally strike, and we can do it on paper as well, the affirmative finding, Your Honor.
All right, so here's the thing with the affirmative finding of family violence. I need to put you on notice what that means. Now, I will read through the police reports, and if it's a family violence matter, then I'm going to find there's an affirmative finding of family violence. But if it's not, then I won't make that finding. Does everyone understand?
Understood.
Yes, Your
All
Honor.
right. So outside the agreement, in the event that I do not grant your application for deferred adjudication, the state is going to recommend that your punishment be set, capped at 4 years in the prison. Did you understand that would just be a recommendation from the state and the court would not have to follow that recommendation?
Yes, Your Honor.
So do you understand that if the court does not grant your application for deferred adjudication, the court could sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Then to count one, how do you plead? Guilty, not guilty, or no contest?
No contest.
And Judge, that's not how I'm sorry, this plea has gotten so cumbersome. The cap, there was supposed to be a cap of 4 years, so you could sentence her from 2 to 4 years.
No. Y'all are not allowed to tell the court if she's applying for deferred adjudication, how much I can sentence her to if I don't follow your agreement. I mean, I'll take it in consideration if I were not to, I'm sorry, not agreement. Your plea bargain is that the state is to remain silent on your application for deferred. So what that means is the state is not going to tell me that they don't want you to have deferred. They're not going to tell me that they do want you to have deferred. Hypothetically, if I were to grant your application for deferred adjudication, the state can make a recommendation and say, Judge, we want her in deferred adjudication for 6 years. I could say, well, no, I'm only giving her 4. I still will have followed your plea bargain agreement. Or, oh, well, I'm giving her 8 years deferred adjudication. I will still have followed your plea agreement. the suggestion that your sentence be a cap of 4, that's not a part of your plea agreement. The part of the outside the agreement is if I do not grant your application for deferred adjudication, then the state will ask that you be sentenced to no more than 4 years. But I don't have to sentence you to 4 years. I could sentence you to more than 4 years. Am I going to do that? I don't know. Am I going to grant your application for deferred adjudication? I don't know, because I'm going to need a PSI report. So that's the agreement. And if people don't understand that as agreement and want to withdraw, you're more than welcome to withdraw. But as far as the state's recommendation of a cap of 4 years, if you don't receive deferred adjudication, that's just something for me to consider, but I don't necessarily have to follow that.
Understood.
We'll still go forward.
All right, so does everyone understand that if the court were not to grant the application for deferred adjudication, that I could potentially sentence you up to 20 years in prison? Do you understand that?
Yes, Your Honor.
Do you understand that the fact that the state would perhaps recommend or will recommend a cap of 4 if I don't grant your application for deferred adjudication, that's just something for the court consider. Do you understand?
Yes, Your Honor.
And do you understand that if I were not to grant your application for deferred adjudication and the state were to recommend that you be sentenced to 2 years, 3 years, or 4 years, and I decided to sentence you to 10 years, that will not have violated your plea bargain agreement. Do you understand?
Yes, Your Honor.
All right. Then to count 1, my understanding you've entered a plea of no contest. Is that correct?
Yes, Your Honor.
Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Probation, I'm going to request a PSI and TAP evaluation. Counsel, is there a need for a mental health evaluation or no?
No.
All right. You're going to come back. I'm going to make my decision on your application based upon the PSI report, the TAP evaluation, and any other evidence that's presented to the court. Do you understand?
Yes, Your Honor.
All right. Once you sign the reset form, be sure to speak with probation. They'll give you information on what needs to be done.
Thank you for the help, Judge.
Thank
Oh,
you, Your
sure,
Honor.
no problem.
Next question.
Here you are. Patricia Munoz. All right, we're here for sentencing.
Yes.
Who's the prosecutor?
Myself, Your Honor.
All right, court is calling 2024 CR 2942, State of Texas versus Patricia Munoz. Can I have parties announced for the record for the state?
Is that done for the state, Your Honor?
Anthony Cantrell for the defendant.
And are you Miss Munoz?
Yes, Your Honor.
All right, you entered a plea of no contest to count 1 on June 10th. Excuse me, don't talk behind the court reporter. That's okay. You all just ask the deputy to move you to the end. On June 10th, you entered a plea of no contest to count 1. The court found there was sufficient evidence to find you guilty. Court deferred finding of guilt as you had applied for deferred adjudication. You entered a plea to aggravated assault with a deadly weapon. State was silent on your application. And it appears that the punishment is to be assessed at a cap of 20.
Yeah, I believe counts from what I remember, state was silent and then range of punishment being up to 20, but I believe.
This is what you all have written.
I apologize. I'm close. I'm like, Rush, that's my bad. Yes, Your Honor. Yeah, in the event that you didn't grant deferred, then yes, that would be the request below the line. Yes, Your Honor.
No. So your plea bargain agreement, according to what I'm reading, is her sentence is to be assessed at a cap of 20 years in the prison, and the state is silent on her application. Is that what I'm reading here?
That's right. And then I'm just saying below the line, Your Honor, just what we had written. In the event that it was, that would be the request or the ask.
All right, let's go off the record for a moment.
And Your Honor, I hope it's okay. We also dated it too, just to show
No.
clarity on our part.
That's it. All right, we're back on the record. So that the plea bargain can be clear. According to the plea bargain agreement, the state is going to be silent on your application for deferred adjudication. So that means they are not going to tell the court that they want you to have deferred, and they're not going to tell me that they don't want you to have deferred. They're saying that if I don't grant your application for deferred adjudication, the most time I can sentence you to is 4 years. Can you raise your right hand for me, please? Do you solemnly swear and affirm that the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. What I just explained to you, do you understand it?
Yes, Your Honor.
Do you understand the plea bargain agreement?
Yes, Your Honor.
Do you have any objections to the state and your attorney adding that as a part of the plea bargain agreement?
No, Your
All right. So have both parties had a chance to review the PSI report? State,
Yes, Your Honor.
defense.
Yes, Your Honor.
Any objections to the PSI report? State,
Nothing from the state, Your Honor.
defense.
No, Your Honor.
All right. Any witnesses? State,
Nothing from the state, Your Honor.
defense.
Just my client.
All right. You may inquire.
Please state your full name for the record.
Patricia Nicole Munoz.
And Ms. Munoz, have you ever been convicted of any other felony?
No,
And did you recently obtain your children in civil court?
yes,
How many children do you have?
5.
And are you taking care of them yourself?
Yes,
Do you have help from your mother and grandmother?
yes, I do.
Mother-in-law.
Yes, I do have a very good support system.
Have you done things in civil court to help you with respect to taking care of your children
Yes, I have.
and helping yourself?
Yes, I have.
Did you complete the family violence prevention services?
Yes,
And you did this on your own, right?
yes,
And are you in elite counseling at this time?
yes, I am.
And have you done this on your own also?
Yes,
And that was also suggested by the civil courts that you do that?
yes, sir.
Okay, you don't have a family violence case though, do you?
No, sir.
With respect to drug use, when was the last time you used any drugs?
In 2018.
And so you've been clean since then.
Yes, sir.
And who do you work for now?
For Santana Primary Healthcare
And how long have you been working with them?
for more than 10 years.
So that's the only job you've ever had?
Yes, sir.
And you still have that job to this day?
Yes, sir.
How has your life changed without your the father of the kid that was Child Protective Services was involved in, with him being out of the picture and you taking care of the children yourself?
Taking accountability for my actions, bettering myself for my children as well as myself. Just having a good support system. And pretty much just trying to better my life for me and my children.
So with respect to this case in itself, there was an issue with one of the boyfriends, one of the girlfriends of the person you were dating at that time?
No, it's actually his niece.
I'm sorry, you need to speak up.
It was my daughter's father's niece.
And she was saying bad things about you.
Yes.
And that was because you were having the child custody issues?
Yes.
And you regret what happened in this case?
Yes, I do.
And if the judge were to give you deferred adjudication, will you follow all the rules and regulations, everything that she asked of you?
Yes.
Past witness.
Any questions?
Silent.
No questions, Your Honor.
How many children do you have?
I have 5.
What are their ages?
9, 7, 5, 4, and 1.
All right, and who's helping you take care of these children?
I am. I have my mother and I have my mother-in-law as well that are helping me.
And is the CPS case still open?
Yes, ma'am, it is.
All right. And do you have documentation that she's doing well in CPS?
Judge, I know that she was awarded custody of the children and they're trying to terminate the father's, one of the fathers who was involved in the CPS matter because he was not getting involved in that. I don't have the documentation with me at this time.
All right. So who's your CPS worker?
Angie Steinau?
All right, if you all want to call the CPS worker, see if the CPS worker wants to zoom in so that I can ask some questions. All right, so if you all step
Will
back, I'm
that
sure she
also-
has the CPS
Would that
worker's
also
number.
Be my drug court monitor as well for drug court. Because I am.
She's one of your CPS, right?
All right, we're back on the record in 2024 CR 2942, State of Texas versus Patricia Munoz. We do have the caseworker by Zoom. Could you pronounce your name for me, please?
Angie Steinow.
All right, Ms. Stownell, if you could raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Angie Steinow.
Do you know Ms. Patricia Munoz?
Yes, I do.
All right, are you the caseworker involving her family case?
Yes, I am.
All right, are you her caseworker or the children's caseworker or the family's caseworker?
The family's caseworker with Family Drug Court.
All right, can you tell me what is her status in the drug court? How is she doing?
Ms. Munoz is almost completed the Family Drug Court program. She has successfully been engaging in individual counseling, family and group counseling with her domestic violence and her substance abuse treatment. She has been randomly drug tested throughout the duration of the case, including hair follicles, which she has tested negative. She also has been reunified with her children since May the 3rd, and the department has done very frequent visits, almost weekly and bi-monthly for the last couple of months. And she's been compliant, doing really well.
When is she due to expire from or graduate from your drug court program?
I believe it's the end of this month. She is in the stage 5 of Family Drug Court, which is the last stage.
And do y'all provide aftercare after graduation or no?
Yes, we do. And she also has a sponsor and a relapse plan.
And how long is your aftercare after she graduates?
It's at least 6 months, and she will continue to do NA meetings.
And in your aftercare program, how often are you all still supervising, viewing the children to see that everything is going well?
We don't particularly observe the children, as CPS will be closing out their case as well. So that will be Miss Munoz going to the continued aftercare program on her own.
All right, so then in your aftercare program, how do you specifically supervise Ms. Munoz?
She will continue to report to her, one of the counselors at Elite Counseling.
And how often does she report to Elite Counseling in the aftercare program?
Twice a month.
All right, and if there are any issues with her reporting in Elite Counseling, are you all made aware of that?
Yes, we are.
All right, any other questions?
Nothing from the state.
No, Your Honor.
All right, a final question for me then. Do you think she would be a danger? I'm assuming you all don't think she would be a danger to her children, otherwise you would not be closing out the case. But do you have any concerns about her interaction with the children or any concerns for her children if she were allowed to be placed on probation in this court?
No, I don't.
All right, do you think there are any conditions that this court should set to make sure she stays on the right path?
No.
All right. Anything else? All right, thank you. Thank you for zooming in.
Oh, you're welcome. Thank you.
All right. All right, court's going to sentence you to 8 years deferred adjudication. I always ask for parenting classes, but if you completed parenting classes, you'll just need to provide the parenting classes that you've completed through Family Drug Court. Do you understand?
Yes, Your Honor.
All right, there's going to be proof of employment within 40 days. There should be no employment as a home health care provider or with minors.
Judge, may I interject on that? Is what she has been doing for the last 10.
Doing what?
Healthcare provider.
And her whole life she's been doing it.
Well, here's the thing. I don't allow people to be healthcare providers when they're on probation in this court. If you want to be a healthcare provider, then there needs to be notice given to whoever you're employed with saying, I know this is what she's charged with. I know she's on probation for this amount of time, and the person that you're providing the healthcare for also needs to be made aware of that. And I need that in writing saying that they have no problem. Otherwise, you're not allowed to do it.
Yes, Your
And let
Honor.
me just tell you, I'm not treating you any differently than anyone else. The reason why I do that is because sometimes these home healthcare providers, they would just hire people. They go into people's homes. Nobody knows if this person is on probation, has a theft, has an abusive history, and they're leaving them with somebody vulnerable. So I'm not going to allow her to be a home healthcare provider probation unless she provides a letter from her employer, and that employer states, and it's notarized, that they're aware that she's on probation for aggravated assault with a deadly weapon, and they're aware of her criminal history. And whomever she is providing the health care to, the individual, they need to provide a notarized letter saying, we know that she's on probation for aggravated assault with a deadly weapon. Here's her history, and it needs to be notarized, and they have no objections. Otherwise, she will not be able to do that.
Understood.
There's to be regular reporting by Zoom or in person. There's to be regular random UAs. You can do the UA or the patch. Probation will explain to you the patch costs more. There's to be no contact with Miranda Medellin. And for the record, the court did not receive any documentation in the PSI from Miranda Medellin. And there's also to be no contact with Renee Vasquez II. There's to be 120 hours of community service restitution. I'm going to order parenting classes. If you provide proof that you completed parenting classes through family drug court, that will be deemed satisfied, and the community service hours will be deemed satisfied. Field visits, one time per month for 4 months. And that one time per month is to begin November of 2024. I'm trying to time it a little bit, probation, with when CPS ends their contact with her. There is to be drug treatment, or I should say continued drug treatment with elite counseling. And you're to report 2 times per month with them. Probation, is there anything else she needs?
No, Judge.
Is there anything else you need from the court to be successful?
No, Your Honor.
Because this is an affirmative finding of family violence, you're not allowed to
Judge.
own.
There is no family violence in this case.
No, there is. No, there is.
She's not related to any of those people. And
There is.
we discussed that. We discussed that last time, also. Prior.
No. This is the niece. These are all family members. And she said it's the niece of the father of her child. Did she not say that?
Yes.
These are family members. So there is an affirmative finding of family violence. And because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
And with regards to the affirmative finding of family violence, it's in the family code. I follow it. If for some reason people believe my interpretation of the family code is incorrect, we can always revisit that. But for now, my interpretation of the family code is this is an affirmative finding of family violence. And my hands are tied. I can't say I'm not going to have an affirmative finding of family violence. Do you understand?
Yes, sir.
All right, we're off the record. Make sure you stay in contact with your probation officer. If there is an issue, let the court know and we'll take it up. You understand?
Yes, Your Honor.
Good luck to you.
Thank you.